Hello, hello, hello. I am back. Let's knock it on out. Come on in, guys. Come on in. Come on in. Let's knock it on out. Let's finish where I left off. I can't wait to read your comments from the earlier live, part one. God must love you. Say to myself, right on, right on. Welcome back, welcome back. Let's get some more people to join us. Welcome back, welcome back. What is it? Just refunded. Oh, heck no. Okay, that's good. Oh, wow. You guys coming on back in here. Awesome. We're almost there. We're almost there. Oh, what kind is this? What is this saying? Oh, that's fine. Oh, maybe I was doing that wrong. What are you talking about? What's up, everybody? Thanks for returning. Right on, Tamara. I see you. I'm ready. 1 second, trying to get some more peeps in here. But like I said, I was doing that wrong. Okay, I think I figured it out. Oh, okay. Did that wrong. See, I'm learning something new. Welcome back, Soul Mahogany. All right, guys, I'm going to go ahead and knock the rest of this out so I can get back to my you know what, my JOBB. So I was trying to wait, but of course, they can always catch it on the replay. So, guys, oh, wait a minute. When I got off the phone, I see you guys sent me some cash apps. Thank you guys so much. You know who you are. I was shocked. Thank you so much. I really appreciate that. So I had to definitely give you guys a shout out. Thank you so much. I left out off on page 80 of the brief. I'm sorry. Are you ready? Are you ready? All right. All right. So I left off here. Trial counsel did not ask the court to question the juror further about his responses to these questions or to determine whether the juror could truly serve as an impartial and unbiased juror in light of having watched the salacious and highly prejudicial docuseries. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about defendant's prior legal issues or his reputation for sleeping with underage girls. Juror number 12 offered several alarming answers in response to the questionnaire that justified disqualification. Told you guys that jury was tainted. I told you. Question 29. Have you read, seen, or heard anything about the case, the alleged crimes, or people involved? Answer, yes. Question. Describe in detail what you recall reading, seeing, or hearing about, etc. Answer. Sex with minors. Specific details do not come to mind. Parodies on TV regarding details of defendant's personal life. SNL, Dave Chappelle, that stupid comedy shit, was in jail prior, then released. Question 32. From what you have seen, read, or heard, do you have a general impression of the defendant? Answer, somewhat negative. Question, why? Answer, I really never cared one way or the other regarding the defendant. The somewhat negative impression is an emotional one impacted by the nature of the charges against him. Boy, people kill me with they judge. Ooh, Lord, all these people kill me judging people. Who the hell you people think you are, though? That's what trips me out when I read shit like that. Who the hell these people think they are? The juror was asked about his or her ability to be fair, and the court obtained assurances from the juror that she could. But trial counsel did not bother to ask the court to inquire about the juror's reference to defendant's, quote, personal life, quote, sex with minors, or Dave Chappelle's SNN skit, which referenced prior allegations against defendant of videotaping a sexual encounter that depicted him urinating on a minor, a crime for which he was prosecuted. It is beyond comprehension that trial counsel would have not moved to strike this juror who had been damning pretrial publicity, who has seen damning pretrial publicity. Knew or thought defendant had already been in jail for these offenses and felt, quote, emotional, quote, by nature of the charges against him. The record reveals that these jurors, 3, 4, 5, and 12, were not capable of deciding the case solely on the evidence before it or acting with impartiality. Beyond these 4 jurors, at least 4 other jurors likely were incapable of acting as indifferent, far, and impartial triers of the fact. However, defense counsel did virtually nothing, they need their ass kicked, to probe the attitudes of these prospective jurors. Jurors number 7, 8, 9, and 11 all revealed that they had heard about the case and the alleged crimes and expressed knowledge about defendant's prior issues with the law. Without exception, trial counsel failed to probe what precisely the prospective jurors had heard or conduct a meaningful inquiry into whether they could be fair given what they had heard or seen. An attorney cannot make an intelligent decision about whether to challenge a potential juror for cause or whether to exercise the defendant's peremptory challenges without properly questioning potential jurors to learn of potential biases. Then she cites a case, Connors versus the United States. I'm sorry, guys. I got to grab some water. My mouth is dry as hell. Give me 1 second. I'm sorry. We'll be right back. I should have grabbed it beforehand. I need water. I'm back. Had to grab some water. I'm sorry. Okay. All right. I told you about this. Citing that case, holding that an adequate voir dire is essential to ensure that prospective jurors would be free of bias and prejudice and would perform their duties impartially. Then she cites another case, Rosales Lopez versus United States, holding that voir dire plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial juror will be honored. Then she cites another case, United States versus Blanc, holding the primary purpose of the voir dire is to make possible an impaneling of an impartial jury through questions that permit the intelligent exercise of challenging by counsel. Under the standing promulgated by Strickland Supra trial, counsel failed to provide effective assistance of counsel to defendant when he failed to move to strike unqualified jurors 3, 4, 5, and 12, and overall failed to conduct a reasonable voir dire to probe the stated biases of several other seated jurors. Baby Robert is coming home. I don't care what nobody say. Just this shit. That man's coming home. That shit was so messed up. The appellate court should beat all their asses, especially to everybody involved. This is really terrible. Okay. And overall failed to conduct a reasonable voir dire to probe that stated biases of several other seated jurors. To prove a successful claim for ineffective assistance of counsel, defendant must demonstrate that 1, counsel's representation fell below an objective standard of reasonableness, and 2, there is a reasonable probability that, but for counsel's unprofessional errors, the result of proceeding would have been different. Yes, you're absolutely right. Strickland, 466 U.S. at 694. In this context, the prejudice prong of Strickland is satisfied by a showing that the juror was actually biased. Then she cites the case Torres, defining actual bias as, quote, bias in fact, end quote, or, quote, the existence of a state of mind that leads to an inference that the person will not act with entire impartiality, end quote. Defendant has satisfied both prongs of the Strickland analysis. As set out above, jurors 3, 4, 5, 12 expressed views that led to the inference, indeed, the certainty that they would not and could not act with entire impartiality. Trial counsel's failure to move to disqualify them was substandard. You know damn well. Apart from their own words that 2 of those seated jurors had seen surviving R. Kelly, is evidence of bias in fact, where no human being could act as a fair and impartial juror after seeing a docuseries that painted defendant as a serial predator. And then she gets footnote number 11. And she, at the bottom for footnotes, she got links here directed. I guess this is the docuseries shit. It's evidence of bias in fact, where no human being could act as a fair and impartial juror after seeing a docuseries that painted defendant as, okay. The docuseries was 11 episodes and consisted mostly of interviews with alleged victims who graphically detailed their claims of sexual abuse. And that's also, that's footnote number 12. In his Rule 33 motion, defendant referred to the district court to the Surviving R. Kelly series, which can be live streamed on several platforms, including Netflix and Amazon Prime. Defendant also embedded the following links in his reply, which are excerpts, but she sure in the hell did. Oh, and Donnelly, they coming for your ass, which are excerpts from Surviving R. Kelly that any juror who had seen the documentary would have seen prior to serving on his jury. And she got the links to that. She sure did put that shit in there. Yes, you did. Of the documentary detailed defendant's prior criminal case that involved allegations of sexual abuse of a 14-year-old, which included allegations that he videotaped himself urinating on the 14-year-old, and which was the subject of the Northern District of Illinois prosecution. It is nothing short of mind-blowing that defense counsel, here go this, what is it, acquitted? Oh, I got to look that up. God damn it. I'm going to say it's a acquitted to the seating of jurors who came to the case with this highly prejudicial information that no human being could have put aside. For his part, defendant explains that he was effectively absent throughout the voir dire process, even though jury selection is a critical stage of trial at which defendant had every right, that's right, to participate. And then she cites the Gomez versus United States case. In a sworn declaration attached to post-trial motions, defendant explained that he played no role in picking his juror. Weren't we just talking about that? He had no access to the questionnaires, which he could not read in any event. He did not participate in any sidebars where prospective jurors were questioned, and did not consent to any juror who had seen the inflammatory docuseries. Defendant had the constitutional right to be present and participate throughout his voir dire process. His declaration demonstrates that he was a spectator, as his attorneys picked a juror without his input, including individuals that should have been struck for cause. Bastards. Because defendant's jury was comprised of several jurors who could not discharge their constitutional duty to be fair and impartial, defendant did not have a chance at defending against the charges. Defendant was denied his constitutional guarantee of a fair and impartial juror as his sixth amended guarantee of effective assistance of counsel when his attorney failed to move to strike jurors 3, 4, 5, and 12, or otherwise conduct any meaningful voir dire of the remaining jurors. Number 8, defendant was denied a fair trial where the government swamped the jury with excessive other bad act evidence, including testimony from 7 additional witnesses who detailed defendant's unusual and graphic sexual activities, his history of transmitting herpes to his sex partners, his abusive conduct toward his girlfriends, and even audio and video recordings of this conduct with women and men, some of whom never testified. Wow, these sick-ass people. With virtually no limitation, the district court permitted... Man, it's hard reading this shit. This shit really pisses me off. Acquisite. Are you trying to tell me how to pronounce it? It's acquisite? Oh, acquisite. Okay, got you. Thank you for that. All right, where the hell I was at? Let me go back. With virtually no limitation, the district court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the, quote, means and method of the enterprise. The, quote, mean and method jurisdiction for the introduction of copious amounts of bad act evidence is gravely flawed because the government's theory of an enterprise is flawed. Where the enterprise consisted of nothing more than the purported sexual misbehavior of the defendant, unconnected to the activities of a discrete enterprise, the, quote, means and methods of an enterprise cannot justify the omission of copious amounts of bad act evidence. As argued, supra, the government failed to prove a RICO enterprise. No matter how much repellent evidence of sexual indiscretions or abusive behavior the government accumulated against the defendant, the fact remains that it was the defendant and the defendant alone who engaged in those affairs, wholly disconnected to the affairs of a distinct enterprise. Unwitting assistance of underlings who carried bags, picked up defendant's prescriptions, and drove defendant's female guests from location to another is not proof of an enterprise. By characterizing defendant's purported decades-long history of abusive conduct toward women as an enterprise, the government not only avoided statutes of limitations, but was free to introduce any unkind or abusive act of a sexual or non-sexual nature as evidence of the enterprise, conveniently avoiding the rule against the omission of propensity evidence. Go on, girl. Notwithstanding, the district court still obligated to conduct a meaningful Rule 403 analysis, which it failed to do. Rule 403 authorizes the exclusion of relevant evidence when its, quote, probative value of substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the juror, or by consideration of undue delay, waste of time, or needless presentation of cumulative evidence. The United States Supreme Court held in Old Chief that, quote, unfair prejudice as to a criminal defendant speaks to the capacity of some conceitedly relevant evidence to lure the fact finder into declaring guilt on a ground different from proof specific to the offense's charge. Then she cites the case Old Chief versus United States. The committee notes to Rule 403 explain, quote, unfair prejudice within this context means an undue tendency to suggest decision on an improper basis, commonly through not necessarily an emotional one, end quote. Advisory committee's notes on federal EVD evidence 403, as Old Chief observed, courts that follow the common law tradition almost unanimously have come to disallow resort by the prosecution to any kind of evidence of a defendant's evil character to establish a probability of his guilt. Not that the law invests the defendant with a presumption of good character, but it simply closes the whole matter of character, disposition, and reputation of the prosecution's case in chief. Reputation of the prosecution case in chief. The state may not show defendant's prior trouble with the law, specific criminal acts, or ill name among his neighbors, even though such facts may logically be persuasive that he is by a propensity a probable perpetrator of the crime. Perpetrator of the crime. The inquiry is not rejected because character is irrelevant. On the contrary, it is said to weigh too much crime with the jury and to over persuade them as to prejudge one with a bad general record and deny him a fair opportunity to defend against a particular charge. The overriding policy of excluding such evidence, despite its admitted probative value, is the practical experience that its disallowance tends to prevent confusion of issues, unfair surprise, and undue prejudice. Then she cites the Michelson versus United States case. Probative value is also informed by the ability to alternative means to present similar evidence. Specifically, the Supreme Court has advised that the, quote, Rule 403 probative value of an item of evidence may be calculated by comparing evidentiary alternatives, end quote. Then she cites the Old Chief case. The district court is afforded wide discretion to exclude evidence that is, on balance, unduly prejudicial. Then she cites the Tavers case. Quote, so long as the district court has consciously balanced the proffered evidence probative value with the risk of prejudice, its conclusion will be disturbed only if it is arbitrary or irrational. As set out below, this court did not consciously balance the probative value of certain proffered government evidence that carry an extraordinary risk of prejudice. A, excessive STD evidence. The government charged the defendant with committing several racketeering acts based on his transportation of Jane and Faith to California and New York, with an intent to expose them to herpes in violation of local public health laws. The district court repeatedly noted that under its interpretation of the statutes, the government was not required to show that defendants transmitted herpes to Jane and Faith. Mere exposure was sufficient. Even if the district court was correct, there was little justification for allowing massive amounts of evidence that defendant purportedly spent decades receiving and transmitting sexually transmitted diseases. Through defendant's personal physician, Dr. McGrath, the government presented evidence of defendant's entire medical history concerning the contraction of sexually transmitted diseases dating back to the 1990s, including his prior diagnosis with such transmitted diseases as gonorrhea and chlamydia. There's some nasty ass heifers he was, man. Them shit, oh my God, them shit, oh Lord. Okay. Dr. McGrath further testified at length about his treatment of defendant for herpes. In addition to Dr. McGrath's testimony, the prosecution elicited testimony from every person who testified about sexual contact with the defendant, about whether defendant disclosed his herpes diagnosis with them. The prosecution also presented testimony from 3 additional witnesses, Geronda, Kate, and Anna, that defendant infected the women with herpes, eliciting descriptions of herpes infection symptoms. And if that was not enough, the prosecution offered extensive documentary evidence regarding defendant herpes treatment, and elicited graphic details from multiple witnesses about the symptoms of herpes. The prosecutors uttered the word herpes hundreds of times throughout this trial. This was no legitimate basis to bombard the jury with excessive evidence about defendant's herpes diagnosis or the fact that he had allegedly transmitted disease to a number of different women. The only issue in dispute related to defendant's herpes diagnosis was, 1, whether he had herpes in 2015 and 2018 when he had sexual relations with Jane and Faith. 2, whether he knew he had herpes. And 3, whether he disclosed it to the women before they had intercourse. Dr. McGrath testified unequivocally that as of 2015, defendant was diagnosed with herpes and was being treated for herpes. Both women testified that they had unprotected sex with defendant and that defendant did not disclose that he suffered from herpes. This evidence went unrefuted. Accordingly, any additional evidence related to defendant's herpes diagnosis and transmission of herpes to other women was unnecessary, cumulative, and unduly prejudicial. B, evidence concerning sexual relations with Aaliyah. Why the hell Aaliyah in here? Why the hell these people talking about Aaliyah? This was the whole, man, this is the whole damn set. This pisses me off. This really pisses me off. The prosecution the prosecution charged defendant with 1 racketeering act of bribery for the sole purpose of getting evidence before the jury about his marriage and relationship with Aaliyah. Over defense counsel's objection, this court permitted the prosecution to introduce testimony from Angela, Jane Doe number 7, another liar. That's not in here. I just said that. Jane Doe number 7, that she allegedly observed sexual interactions between defendant and Aaliyah in 92 on a defendant's tour bus. Now, you know that heifer line. So damn shame. This court erred by allowing this highly, presidential testimony into evidence after initially denying the government's request. Angela's testimony was not relevant under the means and quote means and method theory, since it purportedly occurred pre-enterprise, which the district court concedes in its order. Instead, the district court defended the ruling on the grounds that the evidence was necessary to show defendant's motive for bribery, particularly since defendant would not confess to having sex with Aaliyah. You gonna make the man? Didn't he say he had no sex with that damn woman? And she said it. Whether the defendant had a motive for committing bribery did not justify putting this inflammatory evidence before the jury. Yeah, they knew what they were doing. Even if the government believed that it needed to present some evidence of motive, it did through the testimony of Demetrius Smith, who assisted in obtaining a false identification card for Aaliyah so she could marry the defendant. Testified that in 94, defendant told him that Aaliyah was in trouble and, wait a minute. Let me read that over. Testified that in 94, defendant told him that Aaliyah was, quote, in trouble and, quote, though she was pregnant, thought she was pregnant, end quote. Smith further testified that the decision to marry was, Smith further testified that the decision to marry Aaliyah was made so that defendant could avoid legal issues. The government had plenty of motive evidence to present and had no need for the wildly presidential testimony of Angela that was not corroborated by any way. As such, it was error to allow Angela to testify about her alleged observations on the tour bus in 92. You damn right it was. C, testimony from Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. This court permitted the government to present a whopping 7 additional witnesses to testify about graphic, uncharged bad act evidence concerning dozens of sexual encounters with the defendant. In its order, the district court set out a detailed accounting of the testimony of Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex. Apart from Angela's testimony, which concerned sexual conduct pre-enterprise, the prosecution defended the introduction of this evidence under the catch-all, quote, means and method of the enterprise theory. As argued above, where the defendant and the defendant alone was the enterprise, the, quote, means and method. Justification for the introduction of copious amounts of bad act evidence in simply a free pass as introducing unlimited bad act evidence related to defendant's alleged sexual misdeeds and abusive conduct. This circular logic returns us to the overarching defect in this prosecution, namely that it was a prosecution of defendant's bad character and unpunished sexual misdeeds. It had nothing to do with punishing or preventing the conduct of an enterprise. The district court suggests that Addie's testimony about her sexual acts with defendant was probative of the enterprise, but fails to explain how or why. Addie testified that when she was 17 years, she went one of defendant's concerts. Defendant announced from the stage that only women over 18 could go backstage, and she did not go backstage because she had no identification. According to Addie, 2 bouncers asked them if they wanted to get defendant's autograph, but did not ask their age before bringing them backstage to defendant's dressing room. According to Addie, defendant provided her autograph and engaged her and her friend in sexual activity. I just don't believe this shit. These people, I just can't believe that they really allowed this shit to be said out loud. This is fucking ridiculous. They know that shit is a lie. Wow, I just don't believe it. It just doesn't fit right. Indeed, the way Addie tells it, defendant forcefully assaulted her in the dressing room. Oh my God. Oh Lord. But the heifer that she ain't called no authority. She didn't leave her ass there and go to no police station. She ain't done shit. Oh my God. No one was present for of course they weren't. No one was present for the sexual activity other than the defendant and her friend. Y'all lying asses out of here. This testimony added nothing to the government's theory of an enterprise, particularly where it is unclear that the mysterious, end quote, bouncers even worked for the defendant, and Addie admitted that they would have had no idea she was 17 years old rather than 18. Indeed, all of the other bad act testimony that came from Alexis, Angela, Lewis, and Alex was designed to put before the jury evidence of defendant's propensity to engage in prohibited sexual activity with minors. It shed no light on the evidence of an enterprise. While there was some vague testimony that nameless, quote, bouncers or, quote, associates invited young women backstage or passed along defendant's phone number, there was no testimony that these nameless individuals had any knowledge that these young people were minors rather than 18 years old. If an enterprise is formed simply because members of a rock star or rapper's entourage invite teenagers backstage to meet an artist, the government should be overloaded with RICO. Gone, Jennifer. Prosecutions against recording artists. You know that's right. That a quote bouncer allows a 17-year-old backstage after an R&B concert is not evidence. I'm sure that's what that should have been. After a R&B concert, it doesn't matter. It's not evidence. She is recruiting minors for the defendant's illegal sexual conduct. Through these other bad act witnesses, the jury was inundated with one jarring story after the next of unconventional graphic sex acts, including sexual conduct that many, perhaps most, would consider deviant, e.g. group sex, elements of BDSM, and coprophobia. And she got it's a footnote for 13 too. So that's the 14. Where is the footnote for 13? I don't even see that on here. Oh, there it is. Okay, gotcha. And so that is a Merriam-Webster dictionary. It's given the definition of the BDSM. Sexual activity involving, this is footnote number 13. Sexual activity involving such practices as the use of physical restraint, the granting or relinquishing of control, and the infliction of pain. Footnote number 14, also Merriam-Webster dictionary of coprophilia, marked interest in excrement, the use of feces or filth for sexual excitement. Baby, y'all can have that shit. When considering this mass of prior bad act evidence, cumulatively, its probative value is diminished exponentially as compared to its prejudicial effect. There can be little doubt that defendant's jury was inclined to rectify past injustices by punishing defendant, even if harbored doubt about his guilt on the charged offenses. The risk of prejudice and confusion was particularly acute where the trial devolved into a live rendition of the surviving R. Kelly docuseries, replete with viewings of sexually explicit videos. D. Admission of graphic videos and audio recordings. If days upon days of testimony of other bad act witnesses was not enough, the government was further permitted to introduce private videos of graphic sex acts, some of which have BDSM elements. Government, and she's talking about the exhibits, were group sex acts between Alex, Dominique, and the defendant, which reflected nothing but group sex involving 2 men and 1 woman. Wait a minute. Nothing but group sex involving 2 men and 1 woman who did not even testify. The district court barely defends the introduction of these videos for a legitimate non-propensity purpose. Government Exhibit 328A is a lengthy video of defendant spanking Anna, who was naked and crying, walking back and forth, calling herself a slut and stupid, because she was both. Get the hell out of here. That's what shit she like. That's what I'm saying. I don't give a damn if you don't like what I'm saying. I believe that heifer like that shit. Who does that? That shit is crazy. Oh my God. While defendant looked on. This video was offered for no other purpose than to show defendant's sexual perversion and mistreatment of Anna. It shed no light on whether an enterprise existed and had no bearing on the charged offenses. Crazy ass people. Lastly, and most problematic, the government admitted a video of Anna spreading feces on her naked body and calling the defendant daddy. Although defendant was not depicted in the video, this video, like the others, added nothing to the equation as it relates her nasty, stanky ass. I cannot believe, I'm sorry, guys. That shit just freaks me the hell. That just trips. Oh my God. That shit is crazy. Nothing to the equation that it relates to proving an enterprise and did nothing. I'm sure that's what that is. Did nothing. I'm sure it should have been nothing. Did nothing but breed contempt and prejudice for the defendant. Defendant was entitled to a fair trial on the charged offenses. Instead, with the district court's blessings, the prosecution put him on trial for a lifetime of bad behavior. With a jury already biased against him, and she got C argument number 7, and the admission of a mountain of uncharged bad conduct, defendant was denied his guarantee of a fair trial. You know that's right. Number 9, the district court's restitution award for Jane and Stephanie's herpes treatment was unsupported by the government's evidence. I'm sorry, guys. Let me drink some water. Oh, my God. I got to drink some water after reading that shit. Oh, nasty. I just don't understand how you can get excited with having shit on your body. I'll never understand that. I know he wasn't there. He didn't want to smell that shit. Man, that's tripped out. All right. After a hearing conducted on September 28, 2022, the district court ruled that Jane was entitled to restitution pursuant to 18 U.S.C. section 2429 for the cost of herpes treatment, namely the cost of Valtrex. And she got, that's a footnote number 15. Valtrex is the brand name for the drug Valaclavir or some shit. And then she has a link there for the panel to check that out. For the remainder of her life, an amount of $281,168.18. The court further ruled that Stephanie was entitled to $45,587.20 for the cost of herpes treatment, namely the cost of the Valaclavir for the remainder of her life. Ain't that a bitch? Hey, Jane. The district court abused its discretion in granting Jane nearly $300,000 in restitution for a lifetime supply of Valtrex, where the government failed to establish that. 1. Jane was infected with herpes as a result of any of the charged conduct. 2. Jane has been or will be treated with a suppressive regimen of Valtrex. And 3. Jane will actually treat with Valtrex rather than valacyclovir, whatever that term is, the generic version of Valtrex, which is a fraction of the cost of Valtrex. In short, the district court abused the purpose of restitution statute and granted Jane a windfall reward for costs she has never incurred or will incur, seemingly to punish defendant and compensate Jane for her perceived emotional damages. Preliminarily, the restitution sought for genital herpes treatment is not mandatory, pursuant to 18 U.S.C. Section 2429. Since Jane's contraction of herpes cannot be causally linked to any Mann Act violations, the defendant was charged with a Mann Act violation stemming from a trip that defendant and Jane took to California between April 28, 2015 and May 1, 2015, Racketeering Act 8, and further charged with Mann Act violations related to the trip that the duo took to California in September or October 2015. That's Racketeering Act 9 and counts 2 through 5. Because Jane did not and cannot connect her contraction of herpes with either of those trips, she is not, quote, a victim for the purpose of 18 U.S.C. Section 2429. Under the statute, quote, victim is defined as the individual harmed as a result of the crime under this chapter, namely crimes prohibited by 18 U.S.C. 2421A. Jennifer not playing. Come on, Jen. And that's deciding the case. Okay. The sites, the rules, or whatever you want to call it. By its own terms, mandatory restitution is required pursuant to 18 U.S.C. Section 2429 only when the harm suffered by the individual is shown to be as a result of the specific Mann Act offense. See also, and she states the United States versus Goodrich case. The government ignores that Jane and the defendant commenced a relationship in April of 2015. Jane moved into the defendant's home shortly thereafter, where they engaged in a consensual and legal relationship in the state of Illinois for 5 years. But for 2 isolated trips to California, defendant would never have been convicted of a Mann Act violation related to Jane. The government simply cannot show that Jane's affliction with herpes had any connection to those specific trips. The analysis is the same pursuant to 18 U.S.C. Section 3663, where there is no nexus between the offenses for which defendant was convicted and Jane's contraction of herpes. The Mandatory Victims Restitution Act defines, quote, victim as, quote, a person directly and prominently harmed as a result of an offense for which restitution may be ordered, end quote. And she states the United States versus Goodrich case again. Thus, in determining to whom a defendant owes restitution, the statute requires that 1, to identify the offense of conviction, and 2, to ascertain whether the putative, quote, victim was, quote, directly and prominently harmed by the defendant's commission of that, quote, offense. Emphasis added. The Second Circuit explained, and she cites a case, United States versus Villar, restitution may be imposed only for losses arising from, quote, the specific conduct that is basis of the offense of conviction, end quote. The government has not and cannot demonstrate that Jane's contraction of herpes arose from, quote, the specific conduct, end quote, alleged in the charged Mann Act violations, or the forced labor count related to Jane. Separately, the Second Circuit has held repeatedly that the MVRA requires that the, quote, offense of conviction, quote, directly and prominently harm, end quote, the victim entitled to restitution. Then in the Goodrich site, courts have interpreted this language to impose cause and fact and proximate cause requirements, respectively. Again, the harm suffered by Jane, namely her contraction of herpes, must be directly and prominently caused by the specific Mann Act violations and or forced labor offense. It is not sufficient to state that defendant and Jane were in an abusive relationship in which he transmitted herpes to her at some point. Jane and defendant were in a relationship for over 4 years. Regardless of how abusive Jane now claims, the relationship was, she is not entitled to $250,000 for herpes treatment medication, where she cannot directly or prominently link her herpes diagnosis to the specific offenses for which defendant was convicted. You know that's right. Assuming arguendo, the government demonstrated a sufficient causal connection between Jane's herpes diagnosis and the charged offenses. The government dramatically inflates the cost of Valtrex, even for an uninsured individual. Then she states the United States versus Maynard case. The government bears the burden for proving actual losses, not losses that are hypothetical or speculative. First and foremost, the government assumes without providing any supporting evidence that Jane has and will continue to take Valtrex as suppressive treatment rather than intermediate treatment. The government offered no affidavit, What? I thought they showed that heifer's medical records. Well, I'll be damned. The government offered no affidavit, medical records, or even a letter from Jane's physician confirming that she is following and will continue to follow the remaining of her life a daily suppressive regimen of Valtrex. Dr. McGrath testified that only people who suffered 3 outbreaks a year typically are placed on a suppressive regimen rather than treat the infection on an as-need basis. A simple Google search or a review of CDC guidelines shows that treatment of herpes does not take one form and not everyone is directed to follow a suppressive regimen. Footnote number 16, and that's a link to that site. Wow. It is merely conjecture on the part of the government that Jane has or will remain on a suppressive regimen of Valtrex for the remainder of her life. Even if the government showed that Jane was following a suppressive regimen, the government has inflated the cost of the suppressive treatment. Relying on drugs.com, the government contends that a 30-day supply of Valtrex, $421.29. However, a 30-day supply of the I can't pronounce this damn word, valacyclovir, the generic version of Valtrex, what? Is only 15? And oh my God, $15.31, but they want him to pay that half for $421. Oh my God, and 29 cents for some shit she can get for $15 damn. Are you serious though? Oh my God. So that's a footnote, and she got that in there to prove that. That's a damn shame. Robert, you coming home, baby. Them judges gonna be mad as hell that they time is having to even deal with this shit here. This shit here is ridiculous. Accordingly, even assuming the government's testified its burden and demonstrated that Jane will be on a suppressive regimen of valacyclovir for the remainder of her life, The actual total cost is $9,829.02. So she's multiplying the $15.31 by 12 months equal $183.72 times 53.5. That's the total. Not an outrageous sum of $270,466.18. Oh, the government offered no rationale for why Jane would need to take the brand name drug for valacyclovir rather than the generic version, particularly where the government does not make the same request for Stephanie. In sum, the government cannot satisfy the causal connection between the offenses for which defendant was convicted and Jane's contraction of herpes. But even if it could, the government brazenly attempts to punish defendant and enrich Jane by forcing him to pay $250,000 to Jane, even though there is no evidence that she follows and will continue to follow a suppressive regimen of Valtrex, or that she cannot treat her herpes symptoms with a non-brand version of valacyclovir. B. Stephanie. The government seeks restitution on behalf of Stephanie for herpes treatment dating back to 1999. At the outset, the record does not substantiate the defendant transmitted herpes to Stephanie. Stephanie did not even testify. It's a damn shame. Did not testify defendant infected her with herpes. Indeed, defendant's medical records show that he testified. Thank you, I thought so. Defendant's medical record shows that he testified negative for herpes in June of 2000. What the hell are they doing to this man? I thought I know I heard that, read that somewhere. The man was negative. Oh my God. Oh my God. Dr. McGrath began treating defendant for herpes on some date thereafter in the year 2000. Thus, Stephanie's claim that she was infected with herpes by defendant and not all them heifers lying. Oh my God, 1999 is simply unsupported by the evidence and her own testimony. The government continually overlooks that 1 in 6 people have genital herpes. Defendant is not the source of every person on the planet with herpes. Okay. Stephanie's claim that defendant infected her with herpes is contradicted by known facts. That aside, the government fails to show that Stephanie's purported affliction with herpes occurred between May 1999 and October 15. Girl, go sit your ass down. You know you probably gave it to him with your nasty ass. That man didn't even have that shit. Oh, I'm so pissed at these people. During the conduct alleged in Racketeering Act 2, as discussed, supra, the government must show that Stephanie is a, quote, a person directly and prominently harmed as a result of an offense for which restitution may be ordered, end quote. Then she states the United States version of that Goodrich case. Defendant was convicted for an act of sexual exploitation between he allegedly filmed a single-sex act with Stephanie between May 1999 and October 1999, when she was still 17. Isn't that odd that every damn body is 17? I mean, god damn, what, 17 is a magic number? You people, this stuff is not standing out to you people that believe this shit. You don't find that odd? Oh my God. When she was 17 years of age, restitution may only be imposed for losses arising from the, quote, specific conduct, end quote. Alleged Racketeering Act 2. Because Stephanie cannot show that she contracted herpes from defendant during the conduct alleged in this charge or at all, she is not entitled to, girl, you know that's right, Jennifer, to restitution for herpes treatment. Furthermore, The government's exhibit shows that Stephanie is prescribed valacyclovir, the generic version of Valtrex, which according to, and then she got a link there, should cost only $15.31 per month without insurance. Even if Stephanie was taking valacyclovir daily for the rest of her life, as the government argues, the total future cost would not exceed $643.02. And I'd be, ooh, thank God for you, Jennifer, because they weren't expecting this shit to show up like this, baby. You got their ass. They thought this man was going to be sentenced, and that was it. In sum, Stephanie belated claim that she contracted herpes from defendant is supported by no evidence whatsoever, including her own prior testimony. Defendant did not present the symptoms or being treating. I'm sure they got to be treated. Let me see. I know that's what she meant. Defendant did not present with symptoms or began treating, for herpes until 2000. Even if this court were to blindly accept Stephanie's claim 23 years after the fact, okay, the government cannot demonstrate that herpes was a direct and proximate cause of the conduct specifically alleged in Racketeering Act 2. Accordingly, Stephanie, like Jane, is not entitled to no restitution for the past or future herpes treatment. You know that's right. 10. The district court lacked authority to order the BOP to turn over money seized from defendant's trust fund to the clerk of court for future restitution payments. That's right, Jennifer. Get his damn money back. Oh, I can't wait. Damn. Final judgment was entered against the defendant on June 30th, 2022. This she has the docket number. As part of that judgment, the district court entered an assessment of $900, and then there's a $40,000 JVTA assessment and a fine of $100,000. The district court deferred a restitution finding. On or around August 4, 2020, I'm almost done, guys. I know it's long. I'm sorry. On or around August 4, 2022, the Bureau of Prisons seized roughly $27,000 from defendant's inmate trust account without a court order. They didn't even have a damn court order. They just took this man's money without notice, without filing a lien on the property, without filing a notice of default, and without providing defendant with a receipt for the funds. In a pleading filed over a month later, the government admitted that it directed the BOP to seize defendant's trust fund account monies and sought an order from the district court directing the BOP to turn over the seized money to the clerk of the court for deposit in an interest-bearing account pending a determination as to restitution. The district court granted the order. The district court lacked authority to direct the BOP to turn over roughly $27,000 seized from defendant's trust account. Because defendant was not in default and was not provided with any default notice, there was simply no authority for the government to order the BOP to seize defendant's monies. And then she has a case site here. Likewise, the district court lacked authority to direct the BOP to place the seized funds with the clerk of the court for use against a future potential restitution judgment. Neither the government nor the district court cited any authority for the proposition that the government may restrain defendant's property preemptively for use against a future restitution award that is yet to be entered. Case law on this is slim, but two district court cases provide some insights. And she cites United States versus Hickman. The government moved the district court to authorize payment from the defendant's trust account in order to satisfy the criminal monetary obligation imposed by the judgment against the defendant. ID at 922. The district court denied the request because the government failed to present evidence of default in his payment obligations. And then she also cites another case that's called United States versus Woodward. Denying the government's motion for an order authorizing the BOP to turn over the defendant's trust account funds to pay a court-ordered fine absent any evidence that the fine is unpaid, quote, unpaid or in, quote, default. What occurred in the instant cases is even more problematic, where the government ordered the BOP to seize defendant's money without first seeking leave of court. The government acted prematurely and without legal authority when it ordered the BOP to seize defendant's monies from this trust account, absent any showing that defendant defaulted or had shirked his payment obligation. The district court abused its discretion when it directed the BOP to turn over the funds to the clerk of the court for payment against restitution award that had yet to be entered. Conclusion. We are here. Conclusion. For the foregoing reasons, defendant's convictions must be reversed. Alternatively, defendant is entitled to a new trial. Separately, the restitution award must be vacated and defendant's trust fund monies should be promptly returned to his trust account. Dated April 18, 2023, Jennifer Bonjean, electronically signed by Jennifer Bonjean and Ashley Cohen of the Bonjean Law Group. That is it. That's it, guys. Wow. What do you guys think? What do you guys think? That's it. Man, she put in there every damn thing I was hoping she put in there. You guys agree? She put everything I was hoping she put in there. I just hate they asking for a new trial, man. I was hoping they say just throw this shit out. But I guess you can't say that. But I really don't even want him to have to go through that. Oh, you're welcome. My pleasure. You know I don't mind. Thank you guys for bearing with me. Thanks, Bobby. Thank you, guys. So what are you guys happy? I want to say I'm happy with it. So what do you guys think? Oh, you're welcome, Miss Melanie. I hope you guys happy with it. I don't have any complaints about it. I think she pulled out everything I was hoping that came to light. All that shit was necessary. Cool BJ, you're welcome. Thank you. Thanks to Miriam. Yeah. This is crazy what they did to him. And reading that shit like that, seeing it like, that shit shouldn't have even been in a damn courtroom. That was nothing. Why would they bring that shit and spend the taxpayers' money on that bullshit? That was ridiculous what I just read. What was in that trial? That is just ridiculous. So what do you guys think? Do you guys think it was strong enough to warrant a new trial? I would love to know your thoughts. Yes, that's what I'm screaming. Salorm, that's what I'm screaming. I'm happy with every Jennifer done for. Yes, same here. She did her thing. I guess, I don't know what happened last night. They wouldn't grant her whatever she needed, or she just wasn't taking any chances on them, And she just got that shit in. Thank you, Jennifer. Jennifer, oh, girl, kudos to you, man. I know you're under a lot. I know you are. And to have to deal with this, this is very sensitive. This case here, it's just unbelievable. And I know it had to take all your undivided attention. You couldn't miss a beat with this one. And I just want to tell you, you did your thing, girl. You got everything in there that I was hoping you did. Jennifer, she's doing an awesome job. Awesome job. Even all the shit we don't even know about, but we know she got some things going on behind the scenes that, got her heart. But she came and she did her thing, man. She really did. She did. Well, guys, that's the brief. That's what we've been waiting for. So now, we got to hear, I'm not reading that shit from the government. So y'all going to have to get that shit from them other channels. Because I don't want to hear shit the government has to say. I'm sorry. It's all bullshit. And I'm not about to waste my time with that. But I know other people will. I'm giving you a heads up. I just wanted to hear his. I don't want to hear that shit, that government. It's going to come with the same shit they said during the trial. I don't want to hear that shit. So just so you guys know, okay? So don't beat me up. I'm letting you know way ahead of time. I am not reading that shit from the government because I could care damn less what the hell they got to say. Okay? I'm thrown off because, he did this during the day. I got a replay. Oh, wow. Don't forget, there's a part 1 to this, so I need to name these things properly. Well, I got on here less finished, so they have to know it has to be another part somewhere. But I'm going to mark it. I'm sorry I had, I'm working at the same time, guys. So I apologize that I had to stop in the middle of reading the brief to you guys. But it's all good. We did it. We did it. We did it. We did it. Hey guys, I want to talk to you, but I got to really get to work. I really have to get on my job, and I'm going to come on later and hopefully we can talk about what I read. Is that okay? All right. I'll try. If you guys don't join me, I understand, but I'm going to come on later on and hopefully I get a couple of you guys just to get some feedback. And I'll check out what's in the chat and I'll make some notes from that, from earlier and today. And maybe we could talk about that as well. Okay. Have an awesome rest of your day, guys. Take care. Bye.